Okay, well, it's 2 o'clock, so I think we're going to go ahead and get started. Good afternoon or good morning, depending on where you're joining us from today. My name is Karen Booth, and I'm a partner at Thompson, Hine and the leader of the firm's transportation practice. Joining me today are my colleagues, partner Sandy Brown and Jason Tutrone, and senior counsel Jeff Marino. We'd like to welcome you to today's webinar. This session will discuss how to analyze the competitive effects of the UP-NS proposed transaction to help shippers assess how this transaction may impact your business. Before we begin, just a few housekeeping items. Today's program is being recorded, and we will send you a link within the next few days. The presentation is intended for general information for individuals and organizations on matters of current interest. The thoughts and opinions expressed today are those of individual panel members only and do not reflect the opinions of our clients, employers, affiliates, or Thompson Hine as a firm. The content should not be taken as advice, as the views expressed here are for informational purposes only. If you have any questions during the webinar, and we hope you do, feel free to use the question box located in the control panel on the right of your screen. We will answer as many of the questions as we can at the end of the webinar. In the handout panel, you can download a copy of the PowerPoint slides and the bios of today's speakers. Again, we thank you for your interest, and if you have questions as we go along, again, please use the question box. And now we will begin today's webinar. So the topics that we're going to cover today, and this is a second webinar in our series on the proposed UP-NS merger, is how you all can begin to think about and prepare for the STB review process of this merger. And we're going to spend the bulk of our time today on talking about competitive impacts of this transaction and how you should be evaluating those impacts for your traffic. And then to get you all thinking about conditions that may need to be developed to mitigate any competitive impacts, again, to your business and your rail traffic. So before we really dive into the meat, I just wanted, as background on the next slide, remind everybody what we covered in our last webinar, and that is that major Class 1 rail mergers must have STB approval. The board is the only federal agency that has jurisdiction over this merger in order to give it the green light or not. And the Department of Justice, of course, given its focus on competition generally, they certainly can express an opinion, just as any industry participant can. But again, they cannot determine whether or not this merger can go forward. And so that's a very important point to focus on. When the board reviews this merger, the standard that it has to apply is it must be consistent with the public interest. And you can see just by that phrase, that's an extremely broad term that really requires the board to evaluate and balance a number of different factors and sometimes competing factors. And what we covered in our last webinar, but again, is worth re-emphasizing, is that the rules that the board's going to apply here have never been applied before. They were developed back in 2001 after a moratorium that the STB put in effect following significant number of transactions and consolidation in the industry. And so these new merger rules will apply, and they do require the applicants to essentially show how the new transaction could enhance competition. And what that means is going to be determined in this merger proceeding. I'm sure the applicants will want to consider fairly narrow enhancements to competition, whereas maybe the rail customers would like to see that interpreted much more broadly. Next slide. So again, as part of the merger review, just a reminder, this review will officially kick off when this formal application is filed. The notice of intent was already filed by the applicants, and we do believe that the next step will be a procedural schedule. The applicants have proposed one. They've asked the board to put that out for public comment. We are waiting for that to happen. But based on the timing of that notice of intent, which was filed back at the end of July, the applicants have a 3 to 6 month window to file the official application, which will be a lot of paper. And that window now means that we should see the application filed at the earliest at the end of October, around October 30, or on the other side, on the late end, at the end of January or anytime in between. Once that happens, and the procedural schedule, of course, should be established by then, you can expect to have approximately 120 days to file comments and any requests for conditions you may want to file with the STB. So what should you be doing now? And that's really what this webinar is about. We're encouraging certainly our clients and friends of the firm to be proactive here, not to necessarily sit back and wait, but start thinking about how this transaction could affect your specific rail traffic. You're going to want to start considering your specific facilities that are served by UP and NS. What gateways may be impacted by this transaction? What competitive alternatives do you currently have, whether it's reciprocal, direct competition from other railroads or reciprocal switching? Could there be impacts on that? Maybe a need to even preserve some options at your gateways and these competitive alternatives. And also, just given what we've seen from prior mergers with significant impacts on service in the early implementation days and around the integration of systems, how might this affect your service? And do you need to be thinking about any protections to protect your facilities there? You also may want to consider your trade associations, who will likely take a broader look at the transaction than you will need to do. But engaging as a member of these associations gives you some advantages. You can certainly use the associations to help meet some of your own business objectives, but also influence broader industry initiatives around competition, potentially reciprocal switching and bottleneck issues that we're going to dive into here in a minute, to your own benefit, and frankly to the benefit of the industry at large. So I mentioned that the board has the power to condition any approval of the UP-NS merger should that happen. And that's something else that we think you all need to be thinking about now. And there's options that you'll want to consider should you need a competitive condition relative to your traffic. And that can happen at different points in time in this transaction. You might want to develop a condition and speak directly to the applicants before they file their application. They may contact you as well. That is fairly routine. They will be looking for support for this merger. They're going to go to their customers and their largest customers for that support. But you don't need to give it without some benefit to you. So you may want to be thinking about conditions that should be considered or frankly required of the applicants as a formal condition, not just in a private contract. If you don't work with the applicants in advance, or if what you request of them is denied, you will have the opportunity to ask the STB to impose conditions again upon any approval of this merger. So that's another definitely important consideration. And as part of that, when you're thinking about competitive impacts and based on prior mergers, there can be a need to hire experts in some cases to help you justify the conditions you may be asking for based on the impacts of those or based on what's been done in other contexts. And so that's just a seed we want to plant with you at this point. So what are a few examples of competitive impacts? And I just want to touch on these high level and then let Jason and Sandy and Jeff kind of walk through these in more detail. But the first is the potential to lose a competitive alternative. Again, that could be direct rail-to-rail competition. This is largely an end-to-end merger. There's not significant overlap of the UP and NS networks, but there is some. So there will be folks who can lose a direct competitor. And then again, indirect competition, of course, through reciprocal switching and other means could be impacted. Loss of geographic competition, another major category. Not all shippers are thinking about this. That's why we want to kind of help you identify where you may have geographic competition today and preserve that option. And then very importantly, the extension of existing bottlenecks that is very common in rail mergers. And again, maybe not everybody's understanding how that works. So that's why we're here. So I'm going to now turn this over to Jason, who's going to walk through the loss of competitive transportation alternatives issues.
Thank you, Karen. Well, here, of course, we have two competitors that are combining. So naturally, we have a loss of one competitor, and that could mean that you lose an alternative for your traffic. And this is going to impact really your origins and your destinations. And what you're looking for is a situation where UP or NS serve that origin or destination directly today. And then, of course, as a result of the merger, now you don't have the option to use one or the other. You have to use the combined UP-NS, so you lose a competitive alternative there. There's also a more indirect way that you can see this happen, and that's through situations where maybe you have access, you're at a UP or an NS served facility. You don't have direct access to the other carrier at that facility. But you do get what we would call a switch, a reciprocal switch, so a switch to a nearby competitor, and that might be UP switching over to NS, which has an interchange or a connection point nearby. In that situation, you're going to lose that access to, you essentially lose the competition from NS because now UP and NS combine. The situation is just reversed where NS is the direct, serves the facility directly, and UP is that nearby competitor. So those are two of the key ways you see a loss of alternatives. Of course, as I said before, this is really only going to be in areas where UP and NS directly compete today. On the next slide, we'll show you what that looks like. It's a fairly small section of the country. And another thing to keep in mind here is that this is really a location-specific issue. So as individual shippers, you're in the best position to identify it as a potential problem for one of your facilities, and also to identify an appropriate solution to it. And we'll talk a little bit later about what those solutions might look like. As I was saying, this is something that's going to impact you when you're within one of those, within the area where you have overlap of NS and UP. That's going to be in 4 states. You have areas of Iowa, most of, or pretty much all of Illinois. You have northern and eastern Missouri, and then also parts of western Kentucky. And you see that in the blowout here. As locations where you have that overlap. And so there, maybe you have access to both carriers today. That competition between the two is going to go away with the merged UP and NS. Now, if you are outside of this area, this is maybe an analysis you get to avoid. As I said before, if you're outside the area, this loss of a competitive alternative is not going to impact you because today you wouldn't have access to both carriers at your facility. So when looking at your facility, what is it that you're looking for to determine whether or not you've got this loss of an alternative? Are you going to lose access to a competing railroad? So if you're served by both UP and NS, this is going to impact you. Will your facility lose options to construct a connection, which is sometimes called a build out, to a second railroad? So this is a situation where maybe you're situated, the origin or destination is situated on, say, UP. NS has a line that runs nearby, and you've got an option to construct a track that connects from your facility over to the NS line to gain access to competition from NS. And that could be, again, you could have the reverse situation as well. Here, if you have that combination, you're gonna lose that competitive benefit of that build out because it's UPNS either way you look at it. And then a third thing to look at is whether you have a nearby transload option that's served by, say, again, UP serves your origin, and NS might serve the transload facility. Does now, in this situation, what would happen is the combination would then eliminate competition to that facility, and so you could lose that transload facility as a competitive option for you. Now, if you find that you've got a potential loss of competition, what we have seen in the past is that the STB will remedy any loss of rail transportation alternatives. So if you go from having access to UP and NS to just single carrier, so the combined UP-NS, that's what you'll hear us sometimes refer to as a 2-to-1 location. In the past, the board has tried to remedy that, and one way in which it does that is by offering something called reciprocal switching, and this is where the carrier that directly serves the facility has to transfer that facility's traffic to a nearby competitor. So here maybe BNSF might operate nearby, so the combined UPNS would have to provide a connection to BNSF, and that would be what we call a reciprocal switch. Another way is through what we call trackage rights. This is where we give that competing carrier, or the board gives that competing carrier a right to operate trains on the serving carrier's track. So maybe, again, BNSF might be the nearby competitor, and the board might say, okay, BNSF, you get to operate on UP and NS's track to get to that facility that lost competition. In the context of build outs, what the board will do it has done is preserve the ability of the shipper or of that location to construct that same pre-merger build out. It's not going to provide that option for dual service or competitive access that you see through reciprocal switching or trackage rights. It just sort of gives you what it preserves the status quo, which is that build out option. Now, where there is a lost alternative that's not rail, so say you lose access to a transload facility, there the STB may grant reciprocal switching or trackage rights to that transload location, again trying to preserve that competition on the way to that transload facility. Again, that transload facility would still likely be a nearby transload facility. So those are the remedies for loss of transportation alternatives. Now I'll turn it over to Sandy to talk a little bit about geographic competition.
Thanks, Jason. As Jason said, I'm going to talk about the potential loss of geographic competition. So what is geographic competition? It's where a shipper can get the same product from a different location served by different railroads, or can ship a product to a different geographic area served by different railroads. Some of you may recall this term in the context of railroad rate mergers, or railroad rate challenges, where in order to challenge a rate, you have to show that the revenue to variable cost exceed 180%, or your RVC ratio. Most shippers know that terminology. You also have to show that you're market dominant, or that you don't have competition. Geographic competition was part of that assessment until 2001, when it was removed from the rate case scenario in order to simplify that. So if you've heard that terminology before, that may be where you've heard it. What's important here is that geographic competition is a recognized form of competition and that the STB's authority to impose conditions in the merger under the public interest standard is broader than the STB's authority that they would otherwise have in a context outside of a merger. So on the next slide, we're going to have, Jason, if you can go to the next slide. Perfect. Some little drawings, which I'm a map person. I'm definitely a visual person. I like to see little drawings. So this is an example of geographic competition, where this example is, and where it often comes into play, is natural resources, which you can't physically move somewhere else. So this example is coal, where you have Powder River Basin coal in one region served by Union Pacific, and you might have a power, where you would need to move coal to your power plant. You would have Appalachian coal or Illinois Basin coal in another region served by a different railroad, in this case, Norfolk Southern. When those two railroads are independent of each other, a shipper may be able to constrain their pricing for the delivery of coal by pitting UP and NS against each other, such that they, can try to say that they could use different sources. Obviously, it's much more complicated with coal and sourcing of coal. But after the unconditioned merger of UP and NS, there would be zero incentive for the combined UP-NS to consider the different sources as any kind of competitive constraint on pricing or service. I'm going to go to the next slide, Jason. On the next slide, another example of geographic competition is for a company that can produce a product at more than one plant. So in this example, Plant A is served by UP, Plant B is served by Norfolk Southern, and they each have separate independent rail service from UP and NS. Even though each plant is captive to UP or NS, the fact that the shipper could threaten to shift production from a facility served by UP to a different plant served by a Norfolk Southern means that the shipper has some competitive leverage to keep the rates in check. If UP and NS were to merge in this scenario with no conditions, that leverage for pricing would be lost. So the potential remedies under both of the scenarios are similar. Next slide, Jason. These trackage rights, they include trackage rights and reciprocal switching to protect both the supply and the destinations. Trackage rights, as Jason said, are where one railroad is granted rights to operate over the track of another railroad, usually for some fixed or agreed upon fee. You may recall trackage rights, as Jason said, have been granted in the past in other mergers. For many, you might remember BNSF trackage rights agreement that was imposed as part of the UP-SP merger. Reciprocal switching involves transferring traffic between railroads at a designated interchange point under a set switching fee. Railroads have often said, reciprocal switching requires increased operational handling and may need more infrastructure. And outside of the merger context, that is definitely, one of the things that they assert the most often. But as I noted, the STB's authority to impose conditions in mergers, is different than outside of a merger context. Operational feasibility will still be looked at, but where a shipper can show that there's a competitive harm or a loss, they are generally entitled to a condition to remedy that. And in the context of the 2001 merger rules, where the railroads are being asked to really look beyond just remedying competition and looking at enhancing competition, geographic competition is definitely an area that you should be looking at for your particular facilities, your particular supply and destinations, and looking at ways that you can, protect that geographic competition. I'm going to turn it over to Jeff, who's going to talk about some more drawings to help us understand the potential competitive harms.
Great, thank you, Sandy. I'm going to talk about extended bottleneck segments. This is probably the least understood of the harms that we're discussing, yet it is also probably the one that affects most of you. Any of you who ship on through routes that involve a combination of UP and Norfolk Southern have the potential to be affected here. So let's start off by talking on the next slide about what is a bottleneck segment. Simply put, it's the distance that a facility is physically captive to a single railroad, and that distance is usually to the nearest interchange. And it refers to a segment either at the origin or at the destination. And these two illustrations show both of those examples. In the top illustration, the bottleneck carrier is at the origin and it's UP, and there are options to ship on NS or CSX beyond the interchange to the destination. And on the bottom example, we have a destination bottleneck. In this example, NS is the bottleneck carrier, but BN and UP compete for the origin. Let's talk a moment on the next slide about why are extended bottlenecks anti-competitive. And then after that, we're going to cover probably the three most prevalent illustrations of an extended bottleneck that could be anti-competitive. The main reason extended bottlenecks are harmful is because they enable the monopoly carrier to exert market power over a greater distance. And this type of harm can occur regardless of whether we're talking about the bottleneck at the origin or a bottleneck at the destination. However, I will say the harm is likely to be strongest at the origin, and this is because of something that we call the long haul statute. It is part of the Interstate Commerce Act, in which Congress said an origin railroad is entitled to its long haul, which means so long as it's not a really prolonged and inefficient route, the origin railroad can keep the traffic as far as it can take it to the destination before it has to give that traffic to a connecting railroad. And the great threat that comes from an extended bottleneck is what we call foreclosure in the antitrust world. It's the foreclosure of existing rail options beyond what was the bottleneck segment prior to the merger. And I'm going to now talk about that, beginning with the first illustration on the next slide. This foreclosure illustration is of an origin bottleneck carrier. And on the left side, we have the pre-merger, today's situation, where we have UP as the origin railroad, and we have a destination that can be served by NS or CSX. So under the current situation, although you're captive to UP up to an interchange, you have the ability to play NS and CSX off against one another in a competitive scenario to complete the transportation. Post-merger, on the right side of your screen, you now see UP has merged with NS and has a single line route all the way to the destination. Because of the long haul statute, UP doesn't even have to consider CSX. You do not have the option of saying, I want a UP CSX route. You're forced onto the UP single line route. Maybe that's the more efficient route for you, but the point here is you no longer have the choice. And this is where the harm can be, the loss of competition occurs. On the next slide, illustration number 2, we have the reverse situation. This is the destination bottleneck. In this situation today, the origin has competitive service from both Norfolk Southern and CSX, but UP has a bottleneck at the destination after the interchange. Post-merger, we once again have a new UP single line route. Now, the long haul statute doesn't quite work the same way in this situation. You could still, at least theoretically, request a rate from CSX and a joint line route for UP and UP may have to give you that rate. But UP still has the ability to, what we say, demarket that route by quoting a rate in conjunction with CSX that is so high that it becomes uneconomical compared to the single line UP route, thereby effectively eliminating what competition you had in the origin segment pre-merger. On the next slide, we're going to talk about the third scenario. I don't have a name for this one because, but this is actually probably one that may be more common to most shippers. And that's because pre-merger, we have a situation where both the origin and the destination have a bottleneck segment. In this illustration, the origin is Norfolk Southern. Then there is a potential for a interchange with BNSF to carry the traffic all the way to the destination, where BNSF is also the bottleneck carrier. Post-merger, NS and UP merge. Now the long haul statute kicks in. And although you are still captive, you're now captive to a different railroad. Instead of being captive to BNSF, you're now captive to UP, and the ability to have UP and BNSF kind of compete for that bridge section in the middle has completely disappeared. Either route is a two-carrier route. So neither one, theoretically in this example, is more efficient than the other. But you are now captive to UP instead of the BNSF, taking away one option and substituting another at the whim of the railroads who chose to merge. Moving on to the next slide, let's talk about what are potential bottleneck remedies that could be used here. Because it's important to note that the STB, prior to its 2001 merger rules, would not have considered this a loss of competition. They adhered to an economic theory that is now considered to be outdated, saying that there was no, that if you had a bottleneck segment pre-merger, you couldn't lose any competitive options. You weren't any worse off economically post-merger. In the recent CPKC merger, the STB has recognized a shift in the economic thinking in that, and has now recognized that there are actually likely harms from this type of vertical end-to-end merger where you can have extended bottlenecks. So one possible solution is reciprocal switching. Now, this is a solution only for shippers who are within terminal areas where there is a second railroad that you could switch to. But what this does is allows you to access a second railroad that try and to keep competitive options available that may have been foreclosed as a result of the extended bottleneck segment, essentially cutting that or breaking that bottleneck. A typical solution also in a merger proceeding is to have the switch fee prescribed. And that's a bit unique because if the switch fee is set as a result of the merger, then it eliminates a big variable that otherwise is not known, would not be known to you in terms of assessing the effectiveness of this option and creating an economically competitive alternative for you. Now, as I mentioned, reciprocal switching is limited only to terminal facilities. But for shippers who are not in terminal facilities that have access to a second carrier, there also is an option called bottleneck rates. And this is what allows the STB essentially to break the long haul rule and force the railroads to give you a rate that short hauls themselves to keep those options available. The main downside to a bottleneck rate versus reciprocal switching is the railroad still has the ability to set that rate at potentially unreasonably high level that would demarket that option. So you still would have to pursue a rate challenge if the bottleneck railroad did set its rate at an uneconomical level. However, I will say, because this is a bottleneck, it is typically a short distance. And that short distance can make rate case challenges that have been very complicated and expensive and time consuming in the past, can make them more amenable to a practical and economical sort of litigation. Indeed, the STB's 3 benchmark methodology for small rate cases may be quite well suited to establishing a bottleneck rate. And if anyone wants to understand more about that, we did do a webinar on that about 3 months ago, and that the replay of that is available on our website to understand that. So these are the harms of bottlenecks, the potential remedies of bottlenecks. And with that, I will turn it back over to Karen to bring us home.
Great. Thank you, Jeff. Just really a couple of wrap-up points, and then we'd like to get to your questions. So if you have not yet posed your question, please consider doing so, and you can use the question box for that. So really just kind of, wrapping this up, what are the next steps for you to think about? We wanted to give you some of the tools and concepts while you start to analyze your specific rail traffic, the specific competitive impacts that could apply, the 3 categories we've outlined here. Again, loss of competition, either direct by the overlap in the center of the country, or perhaps a reciprocal switching opportunity that gets closed as a result of this transaction. Second, geographic competition. We've given you some good examples to think through there as you consider your traffic. And then, of course, Jeff's explanation of the bottleneck situation. So we hope that's helpful to you, and we think you should be sort of thinking through those issues as you evaluate your traffic. And then most importantly, if you fall into one or more of those categories, what's the opportunity to develop a condition to address any competitive harm or competitive enhancements that may make sense? Again, remember, new merger rules apply here. There's a need for the applicants to address opportunities to enhance competition, and you have the opportunity, therefore, to advise the board on how that could happen and to protect your traffic should it be adversely impacted or could be benefited. And if that's the case, you want to start thinking about not only what that condition is, but what's the strategy that you would employ to accomplish that condition. And again, it could be through direct negotiation with the applicants. It could result in a private agreement with the applicants where that condition is handled under a contract, so to speak. Or it could happen publicly through comments filed at the board where you ask the board to impose a condition to address any of these either adverse competitive impacts or enhancements to competition that would make sense. And that would be public, but it would become part of the STB's decision. Assuming it approves the merger on conditions, it's enforceable, therefore, through the board as part of its decision, whereas a private agreement, of course, would likely be more or less enforced in a court of law or through arbitration. Next slide. And then just a few other considerations. Obviously, there's some technical issues related to these considerations. We've tried to present these issues as simply as we can through illustration, but you certainly can rely on counsel who understands the issues to help you think through what your impacts are and how you might address them. But we've also mentioned and think it is important that trade associations play an additional role here. because they will be likely looking at this transaction at a broader level across their memberships, whether it's a commodity association or a broader group. But there will be opportunities there to consider more regional conditions, perhaps the reciprocal switching, or maybe even national, because this is a coast-to-coast merger that could benefit your traffic, if not through a direct agreement or conditions in the board's decision, through trade association initiatives. We often hear about as well concerns over railroad retaliation. You know, do I want to stick my neck out at the board? You know, might there be some repercussion for doing so? You want to pay attention to that, of course. We hear a lot about that. It's a legitimate concern. I'll be honest, we don't see it very often in practice, but you know, it's a reasonable concern when you only have one or two options for your traffic. And that's where, again, working with council can help address those issues directly, or you can, of course, go through trade associations under that umbrella and remain more anonymous as you advocate for certain positions to be achieved in this merger. And again, the trade associations may try to address reciprocal switching and the bottleneck relief Jeff was outlining. You know, there's some opportunity there for associations to seek broad conditions that would apply to multiple shippers under certain conditions, presumably. So that really concludes our formal presentation for you all. We are eager to get to your questions. We encourage you to ask them. We're here to answer them for you. And again, thank you very much for joining us today.
We do have a couple questions, Karen. Happy to jump in and read one out. The first one is a question about the loss of competition. Does the STB care about how the different railroads approach the marketplace? For example, NS is willing to listen to OD opportunities where the UP is driven by their tariff is their tariff and there's nothing left to discuss. It's a great question. And it's something we've been thinking about as well, because in addition to sort of their different personality issues, each of them have different provisions, in their tariffs. And there is some concern that a combination of two railroads will be a combination of the worst provisions available in any particular tariff, and or maybe their worst personality traits. So it's definitely something to be thinking about, and it is something that I think the STB, given the current environment, given the new rules, given where the industry could go with the approval of a large transcontinental merger, those kinds of issues, will be relevant to the discussion.
Yeah,
yes,
I would add on that. Historically, the STB has not been very receptive. If an example of this is the CPKC merger, where a lot of shippers of toxic inhalation hazards were complaining because KCS had a much more liberal tariff on indemnities than where CP had the most onerous tariff among all the railroads on indemnities. And the STB just was not receptive to that because they said it's not a consequence of the merger. Now, having said that, the CPKC merger was under the old rules. The new rules, although they don't speak directly to this subject, still do strike a tone that might make the STB a little bit more receptive to that type of argument.
Yeah, and Jeff, that's what I was going to sort of echo. I do think that given that issue was raised in CPKC specifically, and frankly was implemented very quickly by the applicants as soon as the approval was reached by the board, I think the board heard from a number of hazardous materials shippers right after that approval to say, kind of, see, we told you, and this is a problem. So I'm hopeful that the board might be more receptive to thinking about that issue and possibly even addressing it.
I think that dovetails on while we're talking about the new rules with another question I see here, that with the new rules, are there any other stipulations besides enhancing competition that might be hard for UP&S to prove? And there is one that immediately comes to mind. The public interest requires that there be net benefits, economic benefits to the public. But in the new rules, the STB also recognized that a lot of those benefits may be attainable through means less significant than a full-blown merger. And so in their application, UP and NS will be required to explain why a merger is necessary to achieve the efficiencies and benefits that they are claiming the merger will provide. And an interesting development on that in the last couple days is that while UP and NS have focused on intermodal transportation, especially with respect to the benefits and efficiencies, only just last week, BNSF and CSX announced a joint venture on intermodal in which they're going to cooperate to achieve many of those same efficiencies. So it's going to be interesting to see how UP claims that it could not achieve these with a merger, without a merger, when BNSF and CSX appear to be poised to do that without one.
And Jeff, I would even take it a step further in that, I mean, I agree, there's a lot to still come on this. And I guess one question is what prevents UP and NS from agreeing to a marketing agreement and alliance to compete more quickly, right? Rather than having to wait for the merger as a short-term step, but that's a very risky proposition because it then exposes them to that argument that you just raised. And I guess what I'm thinking is this move by BNSF and CSX really complicates this a little bit for UP and NS more so than before their announcement because it gives an opportunity for rail customers, for labor, for other class ones to now align around this concept that this merger is not necessary. And, you know, we'll see what kind of alliances form here down the road, but it's quite interesting because it really means that I think BNSF and CSX have tried to one up them here on what is the golden child of this merger, and they can compete for this intermodal traffic with trucks perhaps more quickly than waiting for the UP-NS merger to be approved, which is going to be 18 months to 2 years. So it creates a little bit of a conundrum for I think UP and NS.
Yeah, I mean, the other area I would say too is going to be, sorry, I was going to say, the other area really is going to be service, right? Because every single major merger has had service problems. And there's a requirement to put in a service, assurance plan and to talk about, what happens if those, service commitments don't come to fruition in the oversight, process, and in fact provide, sort of, supplementary conditions that might be imposed if you don't meet those. So I think in addition to competition and service and sort of all of that goes hand in hand. But I think there's going to be a definite increased focus on, service day one and service, day, or year, 5, 6, 7. Jeff, sorry, did you have something else on that?
No, I was just going to say I read an interview earlier today as well that Keith Creel was quoted as basically saying that mergers aren't required to achieve most of these efficiencies.
Yeah, I mean, they've all said that at different times, but look, we have one in front of us and likely an application that will be coming. And I think for every, shipper out there to be looking at their particular situation, which does lead to another question that is there is what's the benefit of a private negotiation for a condition versus, public where it'd be a longstanding provision and governed by the STB. I mean, you can negotiate something and then ask it to be imposed as a condition to the merger. But obviously having it formally imposed as a merger does provide you more long-term, perspective. And I don't know if others want to add to that as well.
Yeah, I mean, I think it's going to be a case-by-case situation in terms of what you're seeking, what else the applicants, may be willing to provide. It could be rate concessions on top of it. Maybe they'll sweeten the pot beyond the condition you want to try to keep it only in a private agreement. So there's really going to be lots of scenarios that you'll have to consider case by case on whether a private agreement makes sense based on a specific negotiation, or, you know, if you're going to want the benefit of it being included in the board's decision with perhaps longer term enforcement capability beyond a breach of contract, statute of limitations, or whatnot. So you're going to have to kind of evaluate that case by case and probably talk to counsel on some of those technical issues.
Another question I see in here is what kind of experts one should consider on this topic. I would say it varies by which type of competition we're talking about here. If we're talking about the loss of alternatives, that probably doesn't even require an expert. It's just your own internal folks talking about they had competition and now they don't. If we're talking about geographic competition, potentially there could be a need for an economist on that subject. It really is going to depend on the nature, because some of these geographic competitive issues can be very fact specific. Extended bottlenecks, that's definitely a economist, an antitrust economist who's familiar with the vertical effects of mergers. That is one of the areas where there is potential for both trade associations and individual shippers to do something on their own behalf. The broad issue of bottlenecks, because it affects so many shippers, is a ripe issue for trade associations to take on. However, there is always the possibility that the board might not implement a broad condition, but might be willing to implement a condition for a specific facility if it had a particularly compelling set of facts. This is an opportunity, if your trade association is doing this, to perhaps piggyback on your trade association's economist, economic expert, but you still might want to file a specific request for conditions for your own facilities, just to cover all the bases of a potentially narrow STB decision as opposed to a broad condition.
Yeah, I would add to that, you know, on the geographic competition, I think you could, you know, likely not need an expert, you know, for that, because the railroads have spoken about geographic competition in so many other contexts, so that if you can, you know, have somebody within your company that can do what's called a verified statement working with counsel to show that you even have the threat of that geographic competition. You don't necessarily have to show that you've ever used it or that, you know, it's 100% effective, but if you have the ability to raise it, I think you could potentially do that without the need for an expert. Jeff, there's one on your slide 20.
Yeah, I'm looking for slide 20 in my handouts here just a second so I can see which one.
Jason, I don't know if you can go back to slide 20.
Jason,
that'd be great. Yeah, you can pull it up
help.
there. It's your illustration number 1.
Here we go.
Okay, and the question is, if the new UP direct route versus the competitive UP CSX route is significantly longer in mileage or transit days, is there any remedy considering the long haul statute? The answer is yes. The statute itself does create exceptions for circuitous routes. So UP could not force its single line route if it was a dramatically longer and less efficient route than the UP CSX combination.
Are there any other questions? Okay, well, we do really want to thank you for your interest in attending today's webinar. As a reminder, today's program was recorded. We will send a link to you within the next few days. If you're not currently receiving our updates and invitations, we invite you to go to Thompson Hine's website and register to receive our mailings under the publications tabs. Again, thank you all for your interest in attending today's webinar. We appreciate that. We're here to help answer questions. If you have them after the webinar, you can contact any of us here on this last slide, and enjoy the rest of your day. Thank you very much.